At the resumption of today's proceeding at the Federal High Courts, the matter involving Mazika Nnamdi Kanu versus the Federal Republic of Nigeria, the matter came up before Justice James Kolawole Omotosho of the Federal High Court in Abuja. At the resumption of proceedings, the prosecuting counsel, Adeboyega Awomolo SAN, informed the court that the the matter is for the defendant to enter his defense. The defendant, who is also representing himself, Mazi Nnamdi Kanu, however, informed the court that he has a motion to file, that he has not been allowed to file that motion for the past 3 days. The judge asked why. The DSS officers mentioned that there are protocols and procedures that upon which his movement is set. They explained that his consultants, that his legal consultants, would have to write to them to request that, oh, he wants to file a motion, so he'll be allowed to leave the facility. The judge then granted a leave that the proceedings be stood down for 1 hour, and then asked the court registrar to come into the courtroom to help him file that motion. And that was done. And upon resumption of the trial today of proceedings, Awomolo SAN, who is the prosecuting counsel, said he would not respond to the motion filed by Kanu, but he would, however, rely on the exhibits attached to that motion, which is a part of the entire court proceedings, which was recorded in the record of the courts. The judge then acknowledged the motion, which was dated 6th and filed 7th, and also a previous motion dated 29th and filed on the 30th of October. He said he has acknowledged this, but he will still stand on his initial order that no preliminary objections, motions would be treated except until judgment. Now, the content of the motion that was filed today by Kanu states the following. One, that his initial not guilty plea be expunged from the court records on the grounds that it was deceptively obtained. It was deceptively obtained, and it contravenes Section 36 of the 1999 Constitution as amended. He also prayed that the court set aside all court orders and proceedings so far on the grounds that it took off on an erroneous foot, having claimed that his not guilty plea was gotten out of deception. Then he asked that the court grant him freedom, immediate freedom. The judge then further pleaded with him to please enter his defense, but he, however, insisted that he cannot enter his defense until he is told under what law he is being tried. The judge, on that note, gave his order that he has given him enough grace, which elapsed today, but if he enters his defense today, he will extend his grace time so he can close his defense. But if he insists on not entering his defense today, he will deem it that the defendant, Mazi Nnamdi Kanu, has waived his right to defense. And on that ground, both the prosecution and the defendant will not write a final address, and judgment is set for the 20th of November 2025.
Your constitution says you cannot try anybody unless the law is written. Show me written law. Show me written law. Don't try it. Don't try it. Don't try rubbish. Don't try rubbish. Useless people. You don't know law. You don't know law. Your own constitution you don't respect. You bring about judgment you don't respect. That's why we the law. Why we the court of law I ask?
This outburst was after the judge gave his made a decision that, okay, since you have refused to enter your defense, and today is the last day of grace that I gave you, I deem it now that you have waived your rights to defense. I set 20th of November as the date for judgment, and also said that both the prosecution and the defense should not write a final address, that he's waiving their final address. They should not write it. That was when Kanu now got angry. That why would he say he should not write his final address? That they must tell him under what law he's being tried so that he can be able to defend himself and all of those things.